All right, let's get this started. I'm David Thornburgh. I am here today as first and foremost as an independent voter here in Pennsylvania. And I've been involved in this effort to open primary elections to independent voters for a good while, but this is a very, very special occasion and a great milestone. I'll just point out the obvious. The backdrop couldn't be beat. And in fact, we've got special dispensation today to rename Independence Hall Independence with an S apostrophe, because that's really what it's all about. But I just wanted to say a few words of introduction, introduce you to the team, this superb team that we have that have come together around this, and then we'll get on with the event and give you folks in the media a couple of minutes to ask questions. As I said, I've been involved in this effort for close to 10 years. There are folks I know, I saw Jen Bullock from Independent Pennsylvanians here earlier who've been doing this for decades, fighting for the rights of independent voters. But again, and that's what we're focused on here today. And I'm joining Michael Smerconish, Jeffrey Doty, and Rachel Shennock as plaintiffs in this King's Bench petition. And the basis of that is our assertion that the Pennsylvania Constitution guarantees us as independent voters the right to vote in every single election. You know, in efforts like this, there are many different arguments to make to many different people in many different kinds of venues. There's sort of the court of public opinion, there's the court of political opinion. We can talk about issues of competition and fairness and reasons why this change is long overdue. But I want to underline again, today our argument and our audience are focused and singular. We're speaking to the 7 justices of the Pennsylvania Supreme Court, and we aim to convince them that excluding independent voters from primary elections is not just unfair in some vague moral sense, but that it violates the Pennsylvania Constitution. How can a Constitution with a free and equal election clause deny 1.4 million voters the right to exercise their franchise in every single election simply because they chose not to join some private association? Well, before I go too much further, I'm not going to get into the weeds of the legal argument because we've got real legal minds here that I want you to hear from. But I wanted to set that tone and that backdrop. Let me introduce this team that we have, this superb team. I'll call it a dream team. I'm going to introduce them in order of appearance all together at once, and they can come up and then individually and say a few words. First is my longtime friend, colleague, former Haverford College classmate, Shane Inspector, who has thrown himself into this effort full bore and brought his team with him. Shane and I, as I said, go way back. Our families go way back, always friends, always colleagues, sometimes rivals. But in the great spirit of political competition and trying to do the right things based on the best available evidence. And I'm sure that Shane and his father is immensely proud of the career that he's built. I'd like to think my dad, who passed away a couple years ago, has been proud of what I've been able to accomplish, and I would say both of them are probably smiling in the fact that we are together on this cause at this juncture. So Michael Smerconish is one of those people who needs no introduction, and then when people say that, they go on and introduce him for half an hour and so forth. But I will say this about Michael, as a political commentator, as a journalist, as a serious student of politics and this country, has a trademark on the color purple. He really is. He's managed to speak to both sides of an increasingly divided political world, trying to find common ground, trying to find common sense, and to stand up for issues like this that he feels important. So I'm immensely grateful to you and your involvement in this effort. The other half of our legal team, Matt Fontana from Fairgrave, Dricker, Biddle, and Reith, is, I'll say, the founding father of this legal argument. It is a mere 6.5 years ago when Matt contacted me when I was the CEO of the Committee of 70, and we were poking around on this issue, and he said, there might be a constitutional case on this. And so here we are, Matt, 6.5 years later, about to give birth to a very, very substantive and serious legal argument. I just am so grateful for your work. And then finally, Jeremy Gruber, a great friend and colleague, who is a senior vice president with the National Open Primaries organization that has been working around the country on efforts like this, again, to support the rights of individual independent voters in states like Pennsylvania to let them vote and to have their free and equal exercise of the franchise. So that is the dream team. I'm going to, again, just ask folks to come up in order. So this would be Shannon, Michael, Matt, Jeremy, and then I'll come back at the end with a couple of closing thoughts, and we'll kind of MC some Q&A. So, Shannon?
Thanks, Dave. And yes, I was thinking the same thing that you were about our days together at Haverford College and the relationship between our dads, and I have no doubt that they would be supporting what it is we're working on today. I have a very simple proposition to advance with you today. I'm going to avoid legal gobbledygook, and I'm just going to say this. The statute that we're dealing with today that prohibits independents from voting in party primaries was enacted in 1937. The legislature didn't pay any attention to independent voters. That's evident from the speeches and the debates at the time. Independent voters were only 3% of the electorate in 1937. And today they are 15% of the electorate. There are 1.4 million Pennsylvanians who have chose to register to vote, but who were disenfranchised in party primaries. And effectively, by not voting in party primaries, they're disenfranchised completely because over 90% of all general elections in Pennsylvania are not competitive. And so we have, on the one hand, a problem which has broadened enormously in the past nearly 90 years, with 5 times as many people proportionally being independents in Pennsylvania. And we also have a problem that is deeper in its nature because the professional and personal cost of affiliating with a political party is much greater than it was in 1937. A man like Dave Thornburgh, who heads a public interest organization, cannot register to vote in a political party without undermining his credibility and perhaps losing his job. A man like Michael Smerconish, who's a journalist, cannot register to vote in a political party without undermining his credibility and perhaps losing his job. It is not fair. It is not right. It's a violation of the Open and Free Elections Clause in the Pennsylvania Constitution, written in 1776, back in that building right there. It's a violation of that provision that these two men cannot vote in a party primary. So we have both a broader problem today than we had 80-some years ago, and we have a deeper problem than we have 80-some years ago, and that's why we're seeking redress in the Pennsylvania Supreme Court. Michael, the floor is yours.
Thank you, Shannon. Thank you, David. I am one of the 43% of Americans who self-identify, according to Gallup, as independent, not as a Republican, not as a Democrat. Think about that, 43%. And as you've heard from David and as you've heard from Shannon, in the Commonwealth of Pennsylvania, there are more than 1 million such individuals who are not registered as a member of a major party, and consequently, we don't have a say in primary elections, notwithstanding the fact that our tax dollars are used to stage those elections. I believe that's a violation of my state constitutional rights, which is why I'm proud to be a plaintiff, along with David and 2 others, in this litigation. I was raised to take voting very seriously. I turned 18 in the spring of 1980 in the thick of a high-profile and exciting Republican battle for the presidential nomination. Like many young voters, I followed my parents into the party of their choosing, and I never missed a general election for the next 30 years. From 1980 through 2010, I voted in every election, both general and primary, such is the way that I was raised. And I did this notwithstanding several moves at an early point in my life, from Bucks County to Philadelphia, and then out to Montgomery County, Pennsylvania. Throughout the 80s and throughout the 90s, I was firmly planted in the party of Reagan and of Bush and of Specter and of Thornburgh. While I occasionally voted for Democrats, I was always voting for Republicans at the very top of the ticket and felt comfortable doing so. I even served in a Republican administration on the watch of President George Herbert Walker Bush. I was appointed as a regional administrator in the Department of Housing and Urban Development and had responsibility for all public housing in 5 states and Washington, D.C. But the Republican Party that I joined in 1980 changed. And by 2010, I was ready to break ranks. As Shannon made reference, as a media personality, I felt boxed in by a label that no longer fit. We live in an era where audiences, be they radio or television, tend to judge you initially by the chyron, the words that are listed underneath your image on television. I felt that I no longer fit what the Republican Party had become and that it was time for me to make a change, not only because I regarded my thinking as critical thinking and independent, but I didn't feel that professionally I could any longer be associated with the GOP. When independents can't vote in primary elections, I think that we all suffer because our missing voice is often one of moderation. We live in very polarizing times, and I firmly believe that when independent voices are excluded from the nomination process, we foster the rise of extreme at both ends of the political spectrum. And better would be a system that forces candidates to have to appeal to a broader cross-section of primary voters, including those for whom compromise is not a dirty word. Consequently, I'm honored to be associated with this action, grateful to the lawyers of Klein and Specter, and Faegre, Drinker, Biddle, and Reith for their extraordinary work in this regard. Thank you. Matt?
I'm a little shorter than everybody. Good afternoon, everybody. I'll be brief because I can't do a better job than Shane of articulating the core legal argument that we're advancing in this case. I just want to make one point, and that's why the King's Bench petition. We see this case, these issues, as raising a substantial constitutional concern. As has been articulated, you have 1 million plus Pennsylvania voters who are unable to translate their vote into effective representation because they are excluded from, in the overwhelming majority of cases, 90% of the cases, the race that is significant to determining the outcome in the general election. Primaries in our present constitutional system play an essential role in electing our representatives, and we believe that independent Pennsylvanians need an opportunity and are constitutionally required to have that opportunity to participate in that primary process. From my perspective, this is a core and essential voting rights issue, and I am privileged representing these plaintiffs, and we look forward to litigating this matter. And with that, I'll turn it over to Jeremy. Thank you.
Thanks, Matt. Good afternoon, everybody. Again, my name is Jeremy Gruber. I'm the SVP of Open Primaries. We're a national election reform organization dedicated to opening primaries around the country to independent voters. As you've heard, more than 1.3 million independent Pennsylvanians are shut out of voting in taxpayer-funded and government-administered elections. Over 1.3 million. Let me put that in context for you, because we talk about numbers a lot, but numbers matter. There are 14 U.S. states where the voting population of all political persuasions, independent, Republican, and Democrat, are less than 1.3 million. So more than the voting population, total voting population of 14 states are being shut out in Pennsylvania's closed primaries. These are states like Nebraska and New Hampshire. Imagine if the entire population of one of those states was shut out. It would be called a voting rights crisis, and this is a voting rights crisis. But it's not just a Pennsylvania one. It's a national one. Independent voters are now the largest and fastest growing group of voters around the country. You heard 1.4 million in Pennsylvania. 30 million independent voters around the country are shut out in closed party primaries. It's not right, it's not fair, and it's downright un-American. We cannot continue to publicly fund primary elections that shut out voters at historic levels that we are, if we want to call ourselves a democracy. And I want to remind people, because we keep talking about these as if they're party primaries. That's what we'd say, party primaries. But if you look at the history of where primary elections came from in this country, it's very far from where they are today. 100 years ago, we didn't have primaries. And what would happen is you as a voter would show up in November, and there would be nothing to vote on, because the party leaders and the special interests would go in the proverbial smoke-filled back rooms, and they would make all the decisions, and there would be nothing for you to do as a voter in November. Primary elections were not invented by the parties. They were invented by the American people to bring themselves into the beginning of the political process during election years, to determine the issues and to determine the candidates. And at the time, they were invented 100 years ago. There was no issue of inclusion because everybody was a Republican or a Democrat. There was no debate about exclusion versus inclusion. It didn't exist 100 years ago. But today, the largest and fastest group of voters are being discriminated against and excluded by these primaries. This case filed today follows a long history of litigation, from women's suffrage through the civil rights era to the modern day. The history of voting rights in the United States is intertwined with litigation, which has served as a crucial catalyst in the evolution of legislation by highlighting discriminatory practices and spurring reform. Almost every voting rights reform ever passed in this country started with a case just like this one. That's why Open Primaries and the Open Primaries Education Fund is proud to support this case. We've been working with David and Ballot PA for 10 years on open primaries in this country. The time is right to focus this conversation, and we're excited to be a supporting member of that. Thank you.
So as promised, let me just say a couple more words, and then I think maybe I'll invite all the speakers to come up here to make the Q&A process easy. I'm going to pick up on a couple of themes that I think have run through various folks' comments. To Jeremy's point, I consider this one of the voting rights issues of our generation. Things are different than they were in 1937, as Shane had pointed out. 3% independents, and now, as Michael pointed out, 43% of folks around the country consider themselves in that case. I did some quick math about how many voters were affected in Pennsylvania over the last 88 years since the statute was passed. And ballpark, pretty good ballpark, this is about 50 million. 50 million voters and their votes have been shut out of this very, very important civic and democratic process. And one thing about that, we ought to think of elections as a hiring process. We're hiring the people that we want to represent us. Campaigns and primary elections, you could say, are kind of like the interview process when we're getting to know them. And we can weigh in, and we can take the big lists and turn it into a shorter list and turn it into an even shorter list to finally make our choice. When independent voters in Pennsylvania are shut out of that process, they're left with a pretty poor choice at the end of the day. There's two people left. And as Shane had pointed out, the shame of it is in legislative elections in the Commonwealth, over the last 25 years, 90% of the time, that's a meaningless choice. So very clearly, and this is, I think, one of the core themes of this petition, if you can't vote in the primary election in Pennsylvania, your vote doesn't matter. And that's a sad comment on our state of affairs, and I think, again, lies at the core of the argument that we're making. We say one point, and I want to stop and give enormous credit to our legal team, Shannon, Chip Becker, Corey Woods, Helen Lawless from the client inspector team, Matt and your folks. This is a serious, substantive, well-researched argument. And I would encourage all of you, not just those of you in the media who are going to maybe cover this, all of you to take a look at it. We'll make it available as we can. It traces the history of how we got here, and I think more important, the consequence of where we are today. One of the phrases, I don't know which of the many authors who attribute this to, said, you know, the Supreme Court has weighed in on various issues that dilute votes, that make some votes more important than others. This is not just the dilution of a vote, this is an evaporation. This is the taking away of the total ability to weigh in to that important process. So let me just close and say, again, to Matt's point, this is a King's Bench petition that says this is urgent, this is important, and we believe it affects a huge number of people from a core constitutional standpoint. We believe that the Constitution affirms our right, regardless of affiliation or lack of affiliation, to vote in every election. And after 88 years, it's well past time that we correct this flaw in the legislation. So, simply put, for those of us who are independents, let us vote. I'm going to ask the speakers to come up here. Happy to entertain questions. If you want to direct it to an individual, fine. Otherwise, I can triage as you will, and I know folks will be available afterwards as well. Yeah, and tell us who you are, just so we know.
Thank you. Carter Walker with Moody. Wondering if you can expand on why the King's Bench petition and not taking it through the normal course of litigation through the lower courts?
That's a lawyer's question to me.
Well, ultimately, it has to be the Pennsylvania Supreme Court who makes the decision to declare unconstitutional the current statute. And for that reason, there's no reason to wait. There's no reason to have a lower court decide the issue first. The case will be decided eventually in the Pennsylvania Supreme Court, and they should do so as quickly as possible. Now, the Supreme Court could decline to accept the King's Bench petition, in which case we would file the action in the Commonwealth Court, and they would make a judgment, and the losing side would doubtlessly appeal. And there is a very, very, very high chance the Supreme Court would accept that appeal. So therefore, the Supreme Court is going to decide the issue eventually anyway, and they should do so in the first instance.
Why not work with them on a different path, or work with legislators on changing the system?
Well, I mean, they're entitled to their own opinion. I think, again, we've spent 6.5 years working on this, and I think now is the right time to move forward. I want to point out something really important that's in the petition. This does not mandate a relief, a remedy from the court. We're just asking the court to rule on whether it's constitutional or unconstitutional. We think it's unconstitutional. This will then go back to the legislature if they agree, and the legislature could choose any number of ways to solve the problem, if you will. So this is not instead of the legislative process. It runs in parallel, and as Jeremy pointed out, this is quite common in these kinds of efforts to have this sort of blended approach to get from here to there.
And it's Gallup from KYW. You're petitioning just for independent voters, not for third-party voters who were also shut out of the primary system?
Yes. If you read the petition early on, it points out there is no such thing as specifically an independent voter in Pennsylvania, but this is a combination of folks who have chosen non-affiliated, and then there's another checkbox that you can use that says other. And inside that other, there are a lot of folks who identify themselves as independent. So it's a combination of those two things.
Could I just add that people who are registered to vote within minor parties are not shut out of primary voting, because there can be primary elections in those minor parties. Sometimes there are. So they are eligible to vote in a primary. It is only the independent voters who are not eligible to vote at all in the primary elections.
Yeah.
Kate Bernard with Philly Empire. If the Supreme Court does not pick up the Kingsbench petition, what is the next step from there? Will you take it through the lower courts?
Yes, yes. If the King's Bench petition is not granted by the Pennsylvania Supreme Court, we will file the action in the Commonwealth Court. They will decide the case. As I mentioned a moment ago, the loser will doubtlessly appeal to the Pennsylvania Supreme Court, and they'll decide the issue ultimately.
Yeah.
What would be the effect?
Just tell us who you are.
Oh, sorry, Mayor Indy from WHYY. If this succeeds, what do you expect would be the effect in a heavily Democratic city like Philadelphia, where the election's always decided in the primary?
Well, the obvious answer to that is simply a math exercise. I think there are about 160,000 now independent voters in well, let me back up a second. It depends on the remedy. I think, again, this does not prescribe a remedy. There's several different ways to get there, and Jeremy knows well that different states adopt different ways of both registering voters and bringing them to elections. So maybe I'll just stop there. We really don't know what the impact would be, except there would be a lot more independent voters, some way, shape, or form. You know, I think we had 16% turnout in this past election in Philadelphia. So that number's going to go up, I guarantee you.
Could I just add, for your understanding of this, if we are successful in the Pennsylvania Supreme Court, then the current statute will be declared unconstitutional, and therefore it will be non-functional. And that will mean immediately that independents can vote in party primaries. Republican, Democratic, Green, Constitution, Libertarian, whatever. As David mentioned, the legislature would be free to fashion other potential schemes with respect to voting, but such a scheme would have to protect the right of independents to vote in primary elections. And that's the core of what we're seeking. The legislature could go with, for example, a California-style system of having no party primaries. Everybody files to run in a primary, and the top two finishers face off in the fall. They could simply leave in place the Supreme Court's rule with respect to independents and not permit, for example, Republicans to vote in Democratic primaries or Green Party candidates to vote in Democratic primaries. They could do that. They have a lot of things available to them. But if we win this case in the Pennsylvania Supreme Court, independents will be able to vote in party primaries immediately.
This is, you're finding this in a year when some justices from the Pennsylvania Supreme Court are up for retention decisions by the voters. How do you look at this? Do you think voters should consider the outcome of this and how the justices handle this when they decide whether to keep those justices?
Well, let me just go back to what I said at the outset. Today's the day we're talking about a legal argument. And there are all kinds of politics that swirl around this, but that's not what we're talking about today. So I wouldn't presume to suggest to voters that they do or don't. We're just focused on, as I said, there's 7 members of the Supreme Court. We think this is an urgent and important matter, and we want to bring it to them expeditiously.
Do you think it puts more pressure on those justices, though, to file it in this particular year?
I'll go back to what I just said. This really, we're filing a legal case here. And there's all kinds of collateral things that people can talk about, and there's a whole industry of folks that talk about this kind of stuff all the time, but we'll leave it to them for the time being.
David, I know you mentioned the Pennsylvania General Assembly. Before leading this petition, did you have any conversations with those in the General Assembly to get their thoughts on this decision? And do we know, I guess, generally speaking, what Governor Josh Shapiro's thoughts are on the current primary system in the state?
Well, I'll point out just a factual matter. When he was in the House of Representatives, he supported a law that would have opened primaries to independent voters. But to your previous question, we didn't ask for the counsel or opinions or judgments of members of the legislature in constructing this case. Again, we relied on the talents of these folks and their teams and their knowledge of the Constitution and precedent and all that goes into it. So,
Although I would say it's well worth noting that this morning, Representative Jared Solomon, who's the primary sponsor of legislation in Pennsylvania for open primaries, came out in support of this litigation.
anything else? One more.
When will you actually file?
It's filed.
Oh.
Yep. And if we can get where's Hank? Okay, Hank and Drew, where's Drew? Talk to one of these folks if you want to get a copy of the petition, and they can get it to you. But it's live, as they say. All right, well, thank you all for being here. Again, I'm sure folks are willing to hang around if you want to chat individually, and enjoy this nice, warm July day.